Welcome to PolicyCast. Today, we have Riaz Thingna with us to discuss an important development in international tax. The Bombay High Court has pronounced a judgment wherein the dividend distribution tax rate is capped at the dividend rate mentioned under the India-UK tax treaty. This ruling has significant implications for cross-border dividend taxation and treaty interpretation. Let's get started. Welcome to our PolicyCast series, Riaz. Much has been talked about the decision pronounced by the Bombay High Court last week, wherein it was held that DDT is subject to the tax rate under Article 11 of the India-UK tax treaty, reversing the board for advanced ruling position and the ITAT special bench decision in the case of Total Oil. Can you please briefly explain the issue before the High Court?
Sure, thank you, Shilpa. The Bombay High Court held that the dividend distribution tax paid by an Indian company on dividends distributed to its UK parent shall be entitled to the beneficial dividend tax rate provided under the India-UK Double Taxation Avoidance Agreement. The High Court held that the nature of income is significant to invoke the treaty provisions, and the person in whose hands the tax is levied is not relevant for application of treaty provisions. The High Court noted the legislative history of Section 115O of the Income Tax Act 1961 and observed that dividend distribution tax is a tax on dividend income of the shareholder. The incidence of collection of tax has been shifted to the company for administrative convenience. It also reiterated that unilateral amendments in domestic law cannot override the tax treaty provisions. Accordingly, the High Court set aside the earlier ruling of the Board for Advanced Rulings, which had denied the lower rate as per the treaty, and followed the decision of Bombay Tribunal Special Bench in the case of Total Oil India Private Limited.
That's very well summarized. What are your thoughts on this judgment by the Bombay High Court?
Well, this judgment reinforces the principle that tax treaty provisions prevail over domestic law wherever more beneficial, and unilateral amendments cannot dilute obligations under a bilateral treaty. By affirming that the dividend distribution tax is a tax on dividend income of the shareholders and which falls within the scope of taxes covered under the treaty, the judgment provides clarity on the applicability of capped rates under Article 11, even when tax is collected from the distributing company. Having said that, the issue has generated various conflicting opinions, especially in connection with discrimination between domestic shareholders and foreign shareholders, and the inference of the decision that dividend distribution tax is akin to deducted at source, which concept is not supported by the Income Tax Act.
Understood. Considering the conflicting opinions that have arisen post this judgment, what is the way forward for the taxpayers now?
Right. Given the recent amendments within the domestic law, wherein dividend distribution tax has been abolished and the incidence of taxation or dividend has moved back to the shareholders, this decision may not be useful in the present context. However, taxpayers should evaluate past positions and consider refund claims where dividend distribution tax was paid at domestic rates despite the treaty protection. The taxpayers should keep track of the developments on this issue, as many new arguments are likely to emerge, as there are high chances that the matter will be referred to the Supreme Court to attain finality.
Okay. So, as this judgment marks a significant shift in India's international tax jurisprudence, what are the issues that the taxpayers should keep in mind?
There are a number of issues worth pondering as a result of the judgment by the Bombay High Court. One, what will be the gross-up mechanism to be adopted? Two, how to claim the refund of excess dividend distribution tax discharged by the company in cases where there are no appeals pending before any appellate authorities. Three, who gets the refund? if dividend distribution tax is a tax on shareholders' income, is the refund due to the shareholder or to the company? And 4, can the shareholder claim foreign tax credit for the recomputed dividend distribution tax in its home jurisdiction? So hence there are many questions emerging from the judgment pertaining to the practical outcomes at the ground level.
Thank you, Riaz, for those valuable insights. While this judgment brings much needed clarity on the application of treaty benefits to dividend taxation, there are various nuances which will emerge as the matter moves to the Supreme Court as expected. We hope this discussion helped our listeners understand the implications and possible way forward. We will be back soon with more expert conversations on tax, trade, and policy. Until then, thanks for tuning into PolicyCast.